So, hi everyone. In the last class, we have discussed about the specific portions of the contract, and in today's class, we are going to complete the portion of the bailment, the bailer and the bailee. So, we have discussed till section 164 of the Indian Contract Act 1872, and coming forward to the part of the rest of the part of the Indian Contract Act, we are going to discuss about the responsibility of the bailer, the bailee, the buyer, and the pawnee and the pawnee, right? So when we're talking about the concept of the bailer and the bailee, we have already understood the person who gives his own thing as the concept of the bailment, or he gives his own thing as a bailment. That person is called the bailer. The person who receives the goods is called the bailee, right? So when we're talking about the responsibility of the bailer, then we have discussed that the bailer is responsible if the bailee suffers loss because the bailer had no right to bail the goods or take them back, right? So when we are seeing the situation that the bailer is responsible if the bailee suffers loss because of the bailer and no right to bail the goods or take them back. For example, I am a bailee, right? You are my bailer. You have bailed me a specific part of the land or a specific part of your property, right? For the specific duration of the enjoyment. But it is later seen that you are not the original owner of the space which has been given on rent with your name, right? So the person who is giving the land or home as a concept of the rent is totally considerable that the belly or the person who has taken the good is not the original person who has taken the goods. It must be taken through the belly specifically, right? So it is understood under section 164 that the bailer is responsible if the bailee suffers loss because of the bailer had no right to bail the goods or take them back. It doesn't affect the act or responsibility of the bailee, but it is because of the bailer who had no right to bail the goods and take them back, right? Then we are talking about section 165 where we have discussed about the bailment by the joint owners, right? So when we're talking about the concept of the joint owner, then in that circumstances we need to understand that the joint owners are the persons who is not the original owner only. In the concept of the joint owner, we have observed that there are more than one owners in a specific bailment, right? For example, I want to bail my own specific property, right? So when there is one thing of mine which I want to sell, right? Then it is your duty, your job to ask the owner unless the agreement requiring the consent from the all. Okay. So when we're talking about the bailment by the joint owner, it exactly means a bailee can return goods to one joint owner unless there is an agreement acquiring from them. That means unless there is no specific agreement acquiring acquiring the consent from the all the people, then also the the belled thing can be returned back to any of the joint owner whoever is available. For example, there are around 6 to 7 joint owners of a specific property, right? So when the bailee wants to return the property, then tell me, is the bailee responsible here to return the property with everyone's signature? The answer is no. So the person can receive the property or receive the goods without the um, can receive the goods to any of the joint owners if it has not been, even if it has not been specified by the terms and conditions. But according to the terms and condition, if it is strictly written that the thing must have given to everyone with their consent, then only the person who is the who has the joint owner of the property, unless there is an agreement requiring the requiring the consent from all, right? So when we're talking about the third part, section 166, it speaks about the redelivery without the title. Okay, the title means the surname, right?